right. Hopefully you guys enjoyed the case capsule video. Next, we're going to get a presentation on the case topic from our 2026 Case Committee Co-Chair, Ben Sandlin. Please welcome him.
Thanks. Hello again, everyone.
Hi, Ben.
Hi. Let me get this up here. I hope you're excited. It's been a while since we did like a straight up Fourth Amendment case, so we thought we'd do this one. This is subtitled Thanks, Mom and Dad, because I'll bore you with a quick anecdote. It was probably 8 years ago when I said, we should do like Ancestry.com. It was like Christmas time. I was like, we should do this. And I was going to buy it for my mom and dad. And they were like, no, because what if the government gets our DNA? And I was like, who cares? Like, we're not related to murderers, right? and we didn't do it. So anyway, when we were doing this case, I was thinking about my parents the entire time. Okay, so we are going to talk about these topics today. Spend a lot of time about the Fourth Amendment, talk about the exclusionary rule, which is the specific legal mechanism that your students will be arguing. Talk about the exceptions to the warrant requirement for the Fourth Amendment. And then the suppression hearing itself, which is kind of the procedural area that the trial, so to speak, will be taking part of. And we'll have plenty of time for questions, as always. So we'll start with the Fourth Amendment. This is what the Fourth Amendment says. It is the right of the people, which is us, to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. It is a very lengthy single-sentence amendment, and thankfully we have it broken up pretty well throughout case law, but there's a lot going on with it. Later we'll break down kind of the important pieces of it, but I think it's always important to start with the actual text of the amendment when we're talking about these constitutional issues. So remember, we're from, the first settlers are from Britain, the UK. And English common law, which is what kind of was the foundation of American common law, had this holding. It held that every man's home is his castle. And so nowadays we have like the castle doctrine in self-defense cases. You can use deadly force to defend your home. Kind of similar concept. The government in England couldn't just like bust down someone's door, walk in, and start searching their stuff. They had rules up against that. But in the colonies, because the colonies were a little bit looser than actually back in the homeland, in the colonies, the colonists suffered from writs of assistance or general warrants. And so, soldiers or people who acted on behalf of the government would just show up and say, let me in. I'm looking around for who knows what, but I'm coming in, okay? And the founding fathers didn't appreciate this. And this is a quote from one of the Federalist Papers. It is the very famous "if men were angels" quote, but it does apply because really the Fourth Amendment is a protection against the government. So many amendments are a protection against the government. I mean, that really is a lot of what they were up against, but this one in particular is about, look, if the government is going to be run by us, we need something to protect us from us. And that's what this quote is getting to from Federalist 51. Hamilton or Madison? I couldn't actually find. If anyone knows, let me know. But okay, great, fantastic. It's Madison. I was lied to yet again by the internet. So this is where we come from with the Fourth Amendment. Okay. So again, back in the homeland, we have every man's home is his castle. Here, no such thing. So the founding fathers were pretty upset about this. So we craft the Fourth Amendment. Let's dial in on some particulars now. So the first underlined quote here, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. So there's two things here. There's a search and there's a seizure. A seizure is when you are arrested. That's a seizure of your person. Or when property is taken from you, okay? That is a seizure of your property. A search is when the government looks for stuff. And so they come in your house with a search warrant, which we'll get to in a minute. So there are two different things there. Here in this case, we're going to be dealing with a search, not a seizure. The protection for, quote, persons, houses, papers, and effects. These are the things that the Fourth Amendment protects, okay? So it is a personal right. The Fourth Amendment is a personal right, and it protects all of these things. Your person, so you can't be arrested without a good reason. Your house, because your house is your castle. Your papers, which is just like your stuff. And your effects, which is literally your property. It's very broad. And it protects a lot of stuff, kind of facially, textually. It protects a lot of stuff from government intrusion. It's important to say, and we'll get to this later, it is from the government intrusion, all right? So if it's just like, I bust down your door and I'm coming in, I don't work for the government. And so it's not a Fourth Amendment issue. You're probably going to be pretty mad at me. You'll probably call the police, but it's not a Fourth Amendment issue. It talks about how there cannot be an unreasonable search and seizure. So it presents a question. Is there a such thing as a reasonable yet warrantless search and seizure? And of course there is, because I'm a lawyer and we live for exceptions. So we will get through those. But exceptions, that's where we get exceptions to the warrant requirement. It is a reasonable search despite no warrant, okay? And that's the land that we're living in here. Protections against general warrants and writs of assistance come in the particularity clause of the Fourth Amendment, that the warrant, first of all, is supported by probable cause by oath or affirmation. So normally by affidavit or declaration by a law enforcement officer or someone similar. They walk in, they have to convince a judge that there is probable cause that they will find evidence or that the person who will be arrested has committed a crime. And that's their burden. They have to do that. Of course, in a search warrant application, the defendant isn't sitting over there like, no, I didn't do anything. So it's pretty one-sided. I'm not saying it's easy to get a warrant by any means, but I'm also not saying it's the most difficult thing in the world, okay? I think even the prosecutors that will watch this later, that I work with every day, will agree with me on that. So the protection against a general warrant, though, is that, first of all, that oath and affirmation aspect, and also the particularity requirement. Okay, so if a search warrant says, I'm going to go in this house, this is the very specific address that I'm going to go into, I'm going to look for this very particular thing, and I'm going to get that very particular thing. That's what the government's allowed to take. Now, they can look through places in the house and drawers and safes where that thing could be. So if you're looking for a cell phone, for example, they're going to turn that house inside out to find that cell phone. But if they're there to look for a very large piece of furniture, they're probably not allowed to look in every drawer in your dresser, okay? So there's some guardrails up around the particularity requirement to make sure that the police don't just come in on an exceptionally broad warrant to just generally search your house. General warrants still are not allowed. The Fourth Amendment does its lift to make sure that doesn't happen, but it doesn't say, okay, we're gonna let any warrant happen. General warrants are never allowed. So over time, of course, the Fourth Amendment undergoes, it's interpreted, maybe that's the best way to say it, it is interpreted by the Supreme Court and other courts. So the first kind of big thing that the Supreme Court comes out with in recent history is the Fourth Amendment protects people, not places. So like I said, this is a personal right. We have this right. Everyone in America has this right. And it, again, is a very personal right. And I keep saying that because I'll get to an issue in a moment where this comes up. But for now, just remember that this follows every person. Then you have the Katz case. The Katz case says that the Fourth Amendment protects a person's reasonable expectation of privacy. Okay? So there are two components to that. It is a person's expectation of privacy and a reasonable expectation of privacy. I may have said this in a previous year's presentation. I got a kick out of this in law school, but the reasonable person, if the reasonable person didn't exist, we would have a very hard time saying what American law is. There's so many reasonableness tests in American law. This is another one of them. So the way this works is, if there's a search and the defendant objects to the search, they have to prove that they have a reasonable expectation of privacy in that search, that person, me, subjectively, I expected that stuff to be private, that information to be private, and your average reasonable person also would have expected that information to be private. The reasonable person standard is not really up for debate this year. We're not going to look at it too closely, but your students should understand it. It's going to be something I think that judges will be interested in. It does come up in kind of one of the not one of the burdens, but an issue related to the burden. I'll get to the burdens later. And I'm harping on this because a reasonable expectation of, like, I could go out and say, well, I thought no one was going to see me do that crazy thing in public. But of course, I'm in public, and so no one would think that it's private in public. So the subjective interest in privacy is normally easier to satisfy than the reasonable interest in privacy. The reasonable expectation of privacy is an objective standard. It either is or it isn't. And the judge can tell you it is or it isn't, because we bestow them that ability to divine what the reasonable person thinks. That's their job. So let's talk about an example in Katz, of course. Katz was talking on a payphone, and the government had wiretapped the payphone. So they were listening to Katz's conversations on the payphone. And on one hand, you're like, okay, it is a public payphone. It is a walk-up public payphone that he's talking on. But at the same time, like, there's a door on the phone booth, and it's glass all around, and like you can see he's in there, but you can't hear what he's saying unless you put your ear into the window, and then at that point he'd probably shut up, right? So in Katz, they said, yeah, he had a reasonable expectation of privacy when he's talking, even on a public payphone. So that's how the Katz test works, okay? That is a foundational aspect of Fourth Amendment law in this country. The Katz test is incredibly important to our development of the Fourth Amendment. And this is kind of just a broad sweeping statement. There's a lot of case law on the Fourth Amendment, and it's always developing. What someone thought was private 30 years ago may not be private now. If it wasn't private 30 years ago, maybe it is now. We have new stuff in the world that didn't exist 30 years ago. Or when Katz was decided, which was even longer ago. And so this is constantly evolving. There's constantly Fourth Amendment issues that come up. These are routinely heard by the Supreme Court, right? If they hear a very small percentage of cases, a lot of what they hear is going to be Fourth Amendment stuff, just because of how often it touches citizens. The sheer number of Fourth Amendment challenges in this country, inevitably, at some point during the Supreme Court's term, you can almost bank that they're going to hear a Fourth Amendment case, if not many Fourth Amendment cases. Okay, so let's talk about the exclusionary rule. So a couple of kind of logical statements here will flow, but the first is the text of the Fourth Amendment doesn't have a punishment. We say the government's not allowed to use general warrants. They need to get an oath or affirmation. It needs to particularly describe. They can't unreasonably search. Great. So what if they do? And forever, we didn't have anything. It was just we had this amendment, and then nothing necessarily bad happened. So what we did is we just made it up. We just completely made it up one day in a case called Mapp v. Ohio. Okay, this is in the 60s, if you can believe it. So this lady, Mapp, she was... The police were searching, actually, I think for a bombing suspect. And they went in this lady's home without a warrant. They were looking for a bombing suspect, and they found lewd magazines. And at the time, possession of lewd materials was a crime. And so they were like, well, sorry we're here. Arrested. And she was convicted. So that is where Mapp came from. And it went all the way up, and she argued the entire time, look, they came in, they didn't have a warrant for my house, they searched, they found lewd materials, and I shouldn't have been even arrested for this because the government had no right to be there. And the Supreme Court said, yeah, you're right. It definitely violates the Fourth Amendment. And by the way, we're so mad about this injustice, we're going to create this thing called the exclusionary rule. And so the exclusionary rule says, and I should say, that before Mapp, the Fourth Amendment it's a form of words, is what the Mapp court said. It is not a form of words. It's not just text in the Constitution that we read and we care about, but like if we violate it, who cares? Mapp really gave teeth to the Fourth Amendment because it placed this restriction on the government and punished them. Literally, that was the justification, to punish the government if they violated it. So it punished the government, it deterred police misconduct, government misconduct, that kind of thing. What the exclusionary rule does is it excludes all evidence that is discovered in violation of the Fourth Amendment. That's very generally said. And we're going to flesh out some examples later. But this is where it was created in 1961 with Mapp versus Ohio. And the judges put a lot of attention into this because if we let the cops go out, or law enforcement generally, or the government generally go out and violate the Fourth Amendment without a punishment, it really tends to undermine our criminal justice system. It undermines respect for police. It undermines everything. I mean, the exclusionary rule, I can't emphasize, and I encourage you to emphasize to your students, is really a cornerstone of criminal defense in our country. It is incredibly important to our country, and just the integrity of what we do every day in criminal process. Okay, so this is how it works. If the government comes in to your house, let's say they come into your house, they don't have a warrant, they just bust down the door, really bad, and they find, I don't know, take your pick of whatever. I'm not asking you to tell me what you have in your house. You don't want the government to see, but let's say they find it, okay? Great. And then they arrest you. Well, they can't use that evidence that they found against you. That is just the exclusionary rule. That is black and white exclusionary rule. They also cannot use evidence that they derive from the unconstitutionally acquired evidence. And so if they come in, this is where we live this year, okay? So they get the gene sample from Gene Heritage or from Frankie Moya or however you want to spin the facts. They get it from somewhere. And then they acquire the defendant DNA sample. And then they acquire the search warrant for the house. And then they get the signet ring. Okay, all of that comes from that initial search. At least we've written the case that way. We call this the fruit of the poisonous tree doctrine. And by we, I mean the Supreme Court of the United States. They call it that. The thought being, if the initial search is poisoned, then you can't go and pick the fruit from the poisoned tree because it's just as poisoned as the unconstitutional search that it came from in the first place. So we're not going to let you do that. Same justification as in MAP, deters police misconduct, kind of buttons up law enforcement the entire way down to trial. It supports judicial integrity, same justifications. So that's the fruit of the poisonous tree doctrine. That is written into the case. You will see this. I want to touch on two things that, warning, are not in the case, okay? This is not in the case. But it's interesting, and I think your students should know about this. There are two doctrines that are kind of interrelated. The government can use evidence from an unconstitutional search if there are sufficient intervening circumstances that kind of erase the unconstitutionality of the search. So it's like something happens that violates the Fourth Amendment, and the government, maybe, like, let's give some credit here, is like, that was unconstitutional, we can't use it. Ignore. Okay, we're not going to use that. Other things happen, investigative techniques over time, they develop some additional evidence, and they go, oh, okay, now we can go back and we can get a warrant for that location and we can actually get the evidence that we want. That's okay. It's called attenuation. And so it gives a release valve. Like, if you look at a piece of evidence and it's unconstitutionally acquired, you can't be like, oh my gosh, I can never find that again. Of course they can find that again. There's exceptions for everything. So this is one way they can get to that evidence. The other way they can get to the evidence is called the inevitable disclosure or inevitable discovery doctrines. These are different doctrines, but they're so much related that it's not worth just breaking them down in this presentation. But essentially, if they find the evidence from an unconstitutional search, and then they realize it's unconstitutional maybe, but they can piece together other evidence, maybe circumstantial or direct evidence, to eventually have gotten there anyway, they'll say, well, you could have inevitably discovered this information. You inevitably would have discovered it anyway, so we're not going to exclude it. The basis being, we're not going to make the government jump through a bunch of hoops, bells and whistles, and red tape just to get where they were going to get no matter what. If they were going to get there no matter what, we're just going to let them do it. Again, this is not part of your case. I think it's very interesting, though, to explain to the students that, the Fourth Amendment is very, in my line of work, I would say defendant, pro-defendant, right? It's supposed to protect the defendant. And so these two exceptions here are interesting because they're government-favored exceptions. It's where we relax the standard that the Fourth Amendment imposes and say, okay, well, in some circumstances, even though the government acted unconstitutionally, it's okay because they would have inevitably disclosed it anyway, they would have discovered it anyway, the facts are so attenuated from the search that it's okay. It kind of scrubs the taint from the process. So interesting. Not where we are, but interesting. We are going to live in the very easy to digest exclusionary rule followed by fruit of the poisonous tree concepts. Great. And there is, by the way, in the case, it is very explicit that these two doctrines don't apply. And so if for nothing else, your students should be aware of them in case a judge asks them about it. It is in the case materials. Okay, so I asked AI, to give me a quippy little mashup with the Fourth Amendment and genes. And it said, just as a single mutation can affect an entire genetic line, a single constitutional violation can taint all derivative evidence. Think of DNA collected after an illegal search or a suspect identified through a genealogy database as proper legal process. I did not tell it what I was talking about, by the way. So if this is on ChatGPT's mind, then maybe it should be on all of our minds. Or maybe it actually collectively is, because ChatGPT is a reflection of the entire internet. Anyway, I digress. Now we're going to talk about the warrant requirement. And I'm going to slow down here because this is where a lot of Fourth Amendment law lives, breathes, eats, sleeps, dies. Just think of the general case where everything happens right. You know, Target is being investigated for suspected criminal offenses. Government is getting grand jury subpoenas. They're executing search warrants. Everything's fine. You can challenge some of that, but you're probably not going to challenge a lot of that if it's tied up by a really good warrant. Where a lot of the cases live are where the government goes in without a warrant, or they take an action without a warrant. And that can be okay. It's exceptions to the warrant requirement. But for that reason, I'm going to slow down because, again, there are a lot of cases here, a lot of things to consider. This is where the fact-bound nature of our case this year exists. So let's go back to this. And I want to highlight the third bullet point. Is there a reasonable yet warrantless search and seizure? And I said, yes, there is. There is a such thing as a reasonable yet warrantless search and seizure. And this is where we're going to live right now, the exceptions to the warrant requirement. Exceptions to the warrant requirement are when we say, as a society, yes, it is reasonable for the government to have done that because of something. A lot of times you'll hear exigent circumstances. That phrase in Fourth Amendment jurisprudence, or when it's okay for the government to have done something because an exigent circumstance existed and they acted without a warrant. And so we're going to look at some specific examples of this. I highlighted a few of mine. These are, again, not in the case. Open fields. The open fields one is like, look, if you got something in an open field, like, I don't know, plants you're not allowed to plant, we're going to find those. And that's okay. Search incident to lawful arrest. You know, you get arrested, you got you in handcuffs, you're going to get searched, okay? You're just going to get searched. And whatever they find, they will charge you with. Hot pursuit's a great one. Hot pursuit of a fleeing, it used to be hot pursuit of a fleeing felon. You know, if someone beats somebody up and then they dash from the police and then you dash through into your aunt's house, the police are going to come get you because they know you're in there. And as a quick personal anecdote, I will tell you, I've never been in a hot pursuit before, but when I was studying for the bar exam, there was a case that the Supreme Court of Ohio, or the Supreme Court of the United States took up, and it was, well, what if we're in hot pursuit of a misdemeanant? Like, you're drunk in public, and you run into your aunt's house. Like, can we chase that misdemeanant? And the Supreme Court of the United States said, only violent misdemeanants, which I thought was an interesting line to draw. But it does put some color on the Fourth Amendment. Like, okay, we're not going to chase just the guy who, you know, was just screaming at somebody and didn't really cause harm. But if he, like, punched somebody, yeah, we're going to go get that guy. So I think it does put color on what the Fourth Amendment means. So we're going to focus on two exceptions to the warrant requirement. The third-party doctrine and voluntary consent. I am going to tell you that these are two very related doctrines. They are different, and I will parse them the best I can for you now. But if you're reading the case and you're getting frustrated that you're like, I don't know if this is consent or a consent fact or a third-party fact, it might be both. They are quite related. Let's start here. Okay. The Fourth Amendment protects people. We have that, and we have a subjective and an objective expectation of privacy. We have that. That's just cats. So that's kind of our baseline. If you voluntarily disclose information to a third party, you no longer have a reasonable expectation of privacy in the stuff you've given up to a third party. Now, certain people maybe foolishly or not so foolishly think, well, I thought they weren't going to give it to anybody, but you already gave it to them, and so no reasonable person would think that it was going to be private. The reasonable person is not exceptionally foolish. They're not especially smart either, but they're not especially foolish. So the reasonable person in this circumstance would say, yeah, you don't expect that to be private anymore. So I'm going to start from the spectrum of this is pretty clearly or probably a third-party disclosure to maybe not a third-party disclosure. So bank records. I bank at PNC. If the government subpoenaed PNC Bank, they would turn over my records. And they would relate to my accounts, certainly. But I trust PNC to take care of my money. And so the government could get that. It's not really a Fourth Amendment issue. Outbound phone numbers. This is interesting. Like, I dial someone else's phone number. I probably disclosed that to the cell phone company. They have to put that through their database, and then they have to go connect me up with that person. So that's probably a third-party disclosure. Trash is kind of, I should have put trash actually on the super far disclosure. And trash is kind of like categorically, yeah, you don't care about that anymore. You tossed it out. That's just public now. There's great cases of like, or at least stories about police, like, I think this is on Netflix. Police like give a can of Coke to a suspect and then they swab it for DNA afterwards because he throws it in the trash. That's totally fine. That's totally fine. Police can do trash pulls without a warrant. They can watch you put something in the trash and then yank it out of the dumpster and say thanks and just take it back and do whatever they want to do with it. Because you don't care about it anymore. You put it out in public. That's a third-party disclosure. This is interesting nowadays, and this is picking up a lot, is Ring doorbells. So like you're just out and about, okay? Who knows who has a Ring doorbell anymore? I think this is kind of just in the core Fourth Amendment, like public conduct is not private. I think that's where Ring doorbells generally fall. But yeah, you don't know what's happening with Ring doorbells. You're probably disclosing all that kind of stuff to Ring. Alexa's a really big one. I read a fantastic case. Don't do outside research. I read a great case, a real case where the defendant said it was an alibi defense to a homicide. And he was like, I wasn't even there. Like, I wasn't in the apartment at all. And then the government got the Alexa voice recordings, because Alexa, by the way, is always recording, just letting you know that. And the government got the Alexa recordings, and they could hear the defendant's voice on the recording in a fight where he, like, ended up killing this girl. And so he was right. I mean, it's like, is that a third-party disclosure? Maybe. I mean, Amazon owns Alexa. I know that. Internet search history, maybe. I mean, I kind of classify that as outbound phone numbers. Like, I have to send that to my ISP to get a Google result, you know? But there's also an amount of privacy on an internet search history, I think, because, like, that's on my phone, and, like, I have the password to that, or my computer that has my password on it. So that's closer. All online, like, my entire digital footprint is pretty personal, I think. Again, you do have to give it to your ISP, but what you do on a daily basis on the internet is probably your business. There's definitely a lot of argument to be had about all online data being a third-party disclosure. So examples of not being disclosed, not third-party disclosure. Okay, so these are private interests. Again, this is just setting our head on our shoulders about what the Fourth Amendment protects. Cell phone passcodes. This is explicitly protected by the Supreme Court of the United States. It's Riley versus California. Don't look it up. Don't do outside research. But I'm just telling you, that is explicitly protected. Dragnet-style phone location data. And you heard that phrase in the clip, dragnet. A dragnet search is just this it's as close as you get to a general warrant without calling it a general warrant. It's just like, yeah, we're going to search a lot of stuff. We're going to get as much out here as we can. It's not particular enough. So dragnet-style cell phone location data. Where is this person at all hours of the day for months and months on end? Now, if you're looking for my cell phone location data, for a 6-hour window, the smaller the time gets, the more likely it is to be okay. It's not dragnet at that point. It's pretty targeted. But my entire location data, it takes a lot of energy to follow me around for an entire week, I'll tell you that. All cell phone data, same thing. Cell phone biometric access. This is going to get big. I mean, like, I look at my phone and it unlocks what my face looks like. Is that public? Yeah, I mean, you all are looking at me right now, but the fingerprint ID, we used to have those on iPhones. Maybe that's not public. So there's a lot of argument that could be had on biometric data as well, especially stored on cell phones. If you can't tell, cell phones right now are kind of getting like the hot attention of the Supreme Court because cell phones are one of those things that we didn't have 30 years ago. And we live on our cell phones. It's kind of the basis of the Riley decision about the cell phone passcodes. We live on our cell phones. And so the amount of personal data on our cell phones is experiencing a lot of protection. It's good. I mean, just for the general person, it's really good. Okay, so what I'm getting at is, and my examples, by the way, you might not agree with them. I'll be straight up. You might not agree with them. I might not agree with them, but my client wants me to make the argument, right? I mean, it's like, this is where we debate. This is where lawyers live. This is super gray, okay? The third-party doctrines application is very, very gray. I will tell you this. The third-party doctrine is often interpreted as kind of a corollary to the Katz test. And I'm kind of dancing around this right now because I'm trying to frame it out as the case has framed it out. Normally, the third-party doctrine comes up when the court considers whether the defendant has an objective expectation, a reasonable expectation of privacy. And they'll say, well, it's trash, so you don't have a reasonable expectation of privacy in this stuff. How we've done it for you all so you can fully develop a third-party doctrine case is your judge has come out and said, I'm convinced from the briefs that this defendant had a subjective expectation of privacy in this information. I'm also convinced that facially there is an objective expectation of privacy, but government, I'm leaving it open for you to convince me otherwise at the hearing that the third-party doctrine applies, okay? So when the real judges hearing this encounter this, you might do a little bit of legwork to explain to them how their predecessor judge has kind of set this up. It is explicit in the case materials that that's how it's set up. It goes over it multiple times in several different ways. I am just going to flag that, though, from a doctrinal perspective. This normally comes within that initial issue of the objective expectation of privacy. So just be ready for that, and I would suggest you prep your students about that. Okay, new topic. Brain wipe, new topic, voluntary consent. This is just a straight up exception to the warrant requirement, okay? So this is like, yes, they cannot, let's do a pat down search, okay? There is no Terry stop, there's no officer safety issue, there's no incident to law, they just, hey, you stop, and they pat down, okay? And they find, let's say, a weapon, okay, great, and then they charge you with it. The voluntary consent exception can apply in that case to excuse the unconstitutional conduct because any one of us can voluntarily waive the protections that we're afforded in the United States Constitution. Simple fact. You can waive almost anything. So this is like, you mind if I take a look around? And if you say, no, that's fine, they're going to tear you up looking for whatever they can find. A note here, though, this is interesting to tell your students. Scoped consent is limited to the scope, okay? So like if they say, do you mind if I take a look around in your house? It's fine if you go into the kitchen, but nowhere else. Okay, if they go anywhere else, they've exceeded the scope of consent, they're not allowed to do that. Except for in the case they have plain view of, an illegal substance just beyond the door, they're gonna go get that, okay? But if it's just the kitchen and they have no other reason to go anywhere else, they can't go anywhere else. So scope consent is only as good as the scope. Not an issue here, but your students might be interested. When we're talking about consent, the voluntary does the lift. So is it really voluntary consent? And courts will look at the totality of the circumstances to determine whether the consent was voluntary. Totality of circumstances was great to me as a competitor. I love it as a coach. It's sometimes frustrating for the students to be like, well, what does that mean? What do you mean, like, everything is considered? Like, everything, man. Like, how old were they? Where were they? Like, who was saying what to? Like, it is very flexible. And we did that on purpose for this year's case because we want you guys to experience like factual disputes. I like factual disputes in mock trial because that means a witness must be lying. That's really fun from a competitor's perspective. So explore the totality of circumstances. That's what we're looking at here to determine if the consent was voluntary. It's obviously borne out with definitions and examples in your case law, but just understand this is kind of the very broad picture of what voluntary consent is. This is great. Can't be with coercion, right? So if you see this, like, does anyone watch Cops? They're like they're at the car and they're like, can I look around? The guy's like, I really wish you get a warrant. Or like, no, maybe, just straight up no. And they're like, well, I'm just going to tow your car. And he's like, okay, fine. Like, is that really voluntary? We fight about that. Lawyers actually fight about this. So, if there's a threat here, maybe it's coercive, maybe it's not voluntary. Or this is an even better one. Just, I have a warrant, but they actually don't. Let me in. And they're like, okay, fine. That's probably not voluntary. You probably know by now that cops are allowed to lie. Like, that's fine. Generally. I mean, morally, maybe not, but like they can do that in their job. This lie in particular would be potentially especially treacherous if picked up by a defense attorney, but is that coercive? Probably coercive in my opinion. All right, so let's talk about the suppression hearing you all are going to be in. So the defendant is the movant here, okay? So case capsule, right, cold case, homicide, fantastic. I hear you guys have been wanting to murder recently. You have a murder. So defendant is charged, gets discovery, which is the exchange of information from the government. And the lawyer, smart lawyer, is like, let's make this kind of out-of-the-box argument. And it happens pre-trial. So they move to suppress this evidence before any trial. A motion to suppress is a special kind of motion in criminal procedure. It's one that's targeted at the constitutionality of government action. So it's not about whether the evidence is admissible. It's about whether the evidence was constitutionally acquired. Those are two different things. Now, the effect of the exclusionary rule and the fruit of the poisonous tree doctrine, if successful, is, of course, the evidence won't come in. But it's not because the evidence isn't admissible. It's because the government broke the rules in trying to get the evidence. So that's where we are right now. You're at an evidentiary hearing, so it feels like a trial. There's live witnesses, live testimony, obviously, because we've set you up for that. You'll have opening statements, closing arguments. State goes first. That's important. State goes first, not the defense. And the issue for the suppression hearing is the constitutionality of the challenge activity. In this case, it's the search. That's it. That's the nuance. So I'm going to touch here on standing. Standing is a requirement for really any dispute. The standing requirement in a suppression issue is, does the defendant, I'm going to go back to the CATS test, does the defendant have a reasonable expectation of privacy and a subjective expectation of privacy in the search? And this is what I talked about earlier. Your judge has already come out and said, I found that this defendant has standing to challenge this search. This is really important to understand. So I'm gonna emphasize this even though I've already kind of talked about it. We didn't want it to be a case where the judge walks in and is like, well, Frankie Moyo's DNA is the stuff that was given up. You're not Frankie Moyo, so why do you care about what Frankie Moyo does? That is a danger, I'll be honest with you. And so we went above and beyond to convince every judge that touches this case not to think that way. And if they are thinking that way, forget about it. Just suspend reality for the next 2.5 hours and enjoy the case that we've written, okay? And I mean that we have gone out of our way to do that. So in your case, the defendant has presented and convinced the court that they have standing to challenge this activity, to challenge this search. In a warrantless search, the government must demonstrate the constitutionality of the search. So the government bears the burden of proof in this case, in this hearing. And their burden, I think it's the next bullet, yes. The burden is a preponderance of the evidence. So the government's going to have to prove that the third-party doctrine or voluntary consent applies by preponderance of the evidence. A preponderance of the evidence is more likely than not. So it's, if everything is even, 50-50, it's just a little bit. It is literally a modicum, just a small amount, more than 50%. It's not 51%, pro tip. It's 50% plus a little bit. And that's the burden. The government bears that burden. The defense does not bear a burden in this case. Of course, the defense will present a case, and what they will be presenting is the third-party doctrine does not apply, and nobody consented, or at least voluntarily consented to this search. It's kind of where we are. I went over this several times now, but this is a critical piece to this case. And when you read this in the judge's opinion, I hope it stands out because, again, we went out of our way to make sure that it hits home. And I'll just say that the importance of this is if this motion was presented to a judge and they said no standing, you wouldn't have an evidentiary hearing, okay? It would just gone, just no, we're not doing this, waste of time. So we really wanted to make sure that no judges dismissed the defense's arguments out of hand because of the standing issue. So prep your students on that, talk to them about that. I hope it's explicit enough in the case to make that legwork happen. I think it is. The state can, and this touches on the third-party doctrine. Remember I said that it's really doctrinally, it's a part of the objective expectation of privacy, the reasonable expectation of privacy. The judge also went out of their way to make sure that this is clear that we have overcome this threshold standing issue on the reasonable expectation. Government, you're here just to kind of undermine that. Convince me that they don't have this expectation. That's kind of where you can think about the third-party doctrine. The voluntary consent requirement is just straight up. I mean, it is, the government can present this evidence if they prove by totality of the circumstances that the defendant more likely than not consented, or that I guess I should say more likely than not there was voluntary consent to the search, then they will prevail. That's the government's burden. So while there are two burdens that scares a lot of people, I don't view them as two different burdens because, again, of the interrelatedness of the doctrines that we're talking about. The case presents some interesting things to think about, and your students may or may not bring this up in trial, but I think it's interesting. These should drive some arguments. We're talking about searching DNA. And DNA, the case capsule video put well, DNA makes us up. It is what makes us us. And everyone's DNA in this room is like 99.99 the same. Like we're close to a banana, you know, like in DNA realm. Like I think a banana is like 80% human or something like that. So who benefits from doing what the government does? Who suffers from doing what the government does? What are risks of just like innocent people being captured in these gene heritage style searches that the government's doing without a warrant, right? No warrants required. We're just going to search DNA databases now. So think about that. But from the government's perspective, obviously, it's like, well, we're trying to catch criminals, okay? And we didn't bust down Frankie Moyo's door. We just busted down this defendant's door who we think killed this guy. So, of course, the government would say that society benefits and only criminals suffer. There's also, I mean, the search is, it's scientifically new. It's a new technology, newer at least, newer than cell phones. And so think about where you want the Fourth Amendment to go, you know? What if we allow this, then what? You know, slippery slope type stuff. So again, not saying that this is exactly something you're going to close on, but it definitely is something to think about. And when I love the presentation about like one day is the prosecution, one day is the defense. Like this is the kind of stuff that's really great for that conversation. Like what feelings do we want to fester within the judges that are hearing this case to help them understand our side of things? These are the kinds of questions I would ask my students if I were in that scenario. And this is also interesting in this case because of how much we built in the defendant's relation to Moyo, who gave the DNA sample to Gene Heritage. You know, at what point does it transition from, well, it was Moyo's decision to give it to, it's really this defendant's decision to allow the connection to happen? It's kind of attenuated, and as I say that, if you're a lawyer or you're in law school, you might sense the standing issue in that statement. But it is an interesting issue to consider. We think we've made it close enough that question will be front and center with protections up for your students to have good rounds and good trials. But that I would definitely think about this as well. Okay. That is the explanation of the Fourth Amendment, warrant requirement, exceptions, that kind of stuff. I'm happy to take any questions you may have. Yes.
So to be clear, when you said we're not challenging the reliability of the evidence, only the search. It's not, you talked about the genetic mutation of DNA. We're not challenging whether the 25-year-old DNA is actually sufficient to prove it. We're just challenging the search and seizure of that DNA in those records, correct?
Yeah, so the question is, you're not challenging, I'm saying again for the recording, you're not challenging the reliability of the genealogy testing, only the admissibility of the evidence. So front and center, the question is, was the search constitutional? Flowing from the answer to that question is, are we going to use it at trial? I think in the case there are issues about the reliability of the data. Did that make it in? Yes, I'm seeing head shakes. Okay. I haven't got to read the final file. That's why I'm asking. So think about, I'm not going to say no. I'm not going to say yes. I think that, especially in a Fourth Amendment case, there's a lot of room for argument. You know, the totality of circumstances issue is one of them. The third-party disclosure is especially interesting as well, because baked within that are a lot of policy considerations about, well, if you say you're okay with disclosing it, then the government can take it. But what if what I'm disclosing is just, what if you don't have what you think you have? You know, like what if you got something that's just completely wrong? Is that subject to the third-party disclosure? So I'm not going to go out on a limb and say yes, no, either way. I would love to hear more. I learned a lot about genealogy, because again, like I said, I never got to do my Ancestry.com test. So I'm interested to see what the students can come up with. Any other questions? Yes.
Does clicking on an end user agreement give voluntary consent even though you didn't read the end user agreement?
So the question is, does clicking on the end user agreement give voluntary consent even if you don't read the end user agreement? The lawyer in me wants me to, is screaming at me to say, I'm not your lawyer, and this is not legal advice. I would also say read all your contracts. I can't say yes or no in this case, and that's because you're looking at the totality of circumstances. Are you familiar with last year's case, the equitable principles? It's very simple. I mean, we're looking at everything, really. I mean, so if you sign, spoiler alert, like they signed the dotted line, okay? But did they consent? It's still murky enough in the case that you're going to have an argument about it. Yes?
I guess maybe a follow-up to that, but like, kind of like in the video, there was some stuff about dark practices on the website, like what opting in, opting out kind of stuff.
Yes.
Is that correct?
There were mentions on the video about opt-in, opt-out, yes. Mm-hmm. Yeah, the opt-in, opt-out procedure is certainly, you could present, whether the opt-in, opt-out is clear or not clear was the question, and that is something that I think is relevant to the voluntariness of the consent. Anything else? Goodness gracious. A lot less questions than last year. I'm taking note. Yes?
Does the case file refer to it all in the OCLRE trial? There are certain databases that legal evidence. Does anything in the trial talk about any of that in the case file, or would that be outside the scope?
The question is whether the case file refers to kind of approved DNA databases as evidence. I'm not familiar with the Kohnberger trial. Which one is that? Oh, it's the Iowa. Oh, okay. No, that trial is not specifically in the case. Last I saw the case, at least, it wasn't in there specifically. That would be outside research. There's certainly discussion in the case about the use of databases. If you remember from the video, and I mean, law enforcement has a DNA database. They have multiple DNA databases, and so those are, they can upload and check against those. So there's definitely discussion about that in the case file. And then separately from that, you have the gene heritage database, right, which is the privately held, yeah.
So if they were to look up the case, what was it, the California killer or something?
Mm-hmm. The Golden State Killer.
Oh, yeah.
Mm-hmm.
So I should dissuade them from doing any research into cases where this kind of thing happened.
Yeah, the question is whether students should research, for example, the Golden State Killer case. It's a question for OCLRE. I'm not exceptionally versed in the outside research rule. My gut is to say you probably shouldn't do that. But I'm getting nods from Kate. Yeah, don't do that. Formal ask. Please don't research the Golden State Killer case. Any other questions? Okay. Great. Thank you all. I hope you enjoy the case. I look forward to seeing all of you at the Mock Hawk. Sign up is open now. Thank you.